everyone. Today's topic for this video slide at least, well, actually for the whole class, is kind of talking about the legal obligations that we have to adhere to or that we are bound to as social workers, kind of in regards to ethics, because obviously that's what we've been talking about in this class. We have in other classes, especially in individuals and families, really talked about all those pieces of engagement where we talk about informed consent, confidentiality, mandated reporting. A lot of that ties into this because it's specifically related to ethics. And so we'll briefly touch on those, but there's a few other ones that we are held to and that will factor into how we address ethical situations. So this is just going to kind of do an overview of some of the legal obligations that we are held to and have to consider within ethics. So the areas that we're going to cover in this PowerPoint video is the concept of duty of care, duty to privacy, duty to maintain confidentiality, duty to inform, duty to report, and duty to warn and protect. Some of these may be familiar. Maybe all of them will be familiar based on your internship setting or life experience. But these things are, you need to be aware of these things because even if you unintentionally violate some of them because you weren't aware of it, you are still legally held to upholding these as a social worker. So I want to introduce them to you so they're on your forefront and on your radar, as they will come into play probably at some point in your social work profession. So duty of care, to me, this kind of is reflective of what we stand for in the Code of Ethics. There's so many of those principles of like dignity and rights of the human, of dignity and right of every human being, kind of the integrity piece, the professionalism piece, that we are in a profession that cares for people and that we are legally obligated to provide a reasonable standard of care when we're delivering our services. And so this is saying that we acknowledge that we are in a helping position, which often holds a position of power. We can provide subpar services because we can get away with it, but we do not value that. So we are legally obligated to provide good care to all and cannot discriminate. So clients can enter into the helping profession relationship expecting their social worker to present with professionalism and that they will be competent. This is not a signed contract. You do not sit down with your client and be like, I'm going to be a smart social worker. I'm going to be competent. I'm going to stay up to date in my practice. It's an implied contract that takes effect. You enter into this assuming that you will be providing that, and clients have the right to assume that that will occur during their helping profession relationship with you. So services must always meet at least an adequate standard of care, and that standard of care is largely determined by the social work profession. So again, being guided by what is outlined in the Code of Ethics, but also just the general expectation around helping professionals. So when we refer to helping professionals, there's also doctors, nurses, social workers, kind of all fall into that category. There's a lot of ethical talk with, especially in the medical field. If you ever watch like Grey's Anatomy or any doctor show, it's like a minefield of ethical decision making. It's what makes those shows drive and thrive. But often that I'm hoping, I'm not a doctor, but I'm hoping some of those scenarios are rather far-fetched, but it does kind of highlight that there's these ethical dilemmas that helping professionals face all the time because, again, we're in a position of power and we are obligated to help. The second one that we cover is duty to privacy. So this is very similar to confidentiality, but it's a little bit different. You are not entitled to intrude on the privacy of prospective or current clients. And so this goes back to the dignity and worth of all humans, is that we need to respect privacy. Again, it's that position of power that we have that we can abuse because we can ask questions or go digging and justify it because we're doing data collection. But that is not the intent of data collection, nor is it an appropriate role. Privacy includes an individual's physical space. So their home, like if we're going on home visits, we don't get to just walk around and act like we own the place. Like we need to respect that this is still their home. They're inviting us in. Yes, it might be really tempting to look around to kind of get a better picture of the person and environment, but that is not our privilege that we can have. Also, I think this to me is a bigger one where social workers are probably more tempted and fall into the guilty category, myself included, is respecting the privacy of the social media space of our clients. Again, for the sake of data collecting, it might be very tempting to Facebook stalk them or look them up on not necessarily white pages because you should know their address, but looking up their criminal history. Are on the sex offenders list, X, Y, and Z, where it's unfortunately can be very entertaining at times as well, and a good source of data collection. We do not have the right to violate that, and most agencies have a policy as well as a code of ethics kind of not enforcing this, but strongly suggesting that you eliminate your searching of clients on the internet and social media as part of the duty to protect people's privacy. The duty to maintain confidentiality. I feel like we do talk about this one ad nauseum in individuals and families, and honestly throughout all of our coursework here, that we know that the law states that we are required to keep the information shared by our clients confidential. It's a rather outdated quote. I acknowledge that this is from 1994, but I think it still summarizes very well the intent of confidentiality and what it is. So confidentiality refers to the professional norm that information shared by or pertaining to clients will not be shared with third parties. Now, obviously, we all know that there's times where we have to breach confidentiality, but obviously that sticks as the rule of thumb. So again, the material that is shared to you by your clients is not your property. Just because you're told it or you've recorded it does not mean that you are now owner of it to disseminate and share however you want. You're just using that knowledge to serve your clients. It is not your property just because it's been shared with you. And under most circumstances, clients will have to give you informed consent before you can share information with another person or organization. That piece all comes in that engagement with a client. So signing the forms of like sharing with insurance companies, explaining mandated reporting, and that you might have to consult with your supervisor. So that informed consent piece is really key to protecting yourself when we're looking at the confidentiality and ethics behind that. Duty to inform. You are obligated to educate your clients and prospective clients that what kind of services you are providing. So this is essentially informed consent. So all of that whole checklist, thinking back to individuals and families, all the things that you cover, telling them what kind of services the agency provides, your credentials, your background, your specialties, all of those things. This is a part of our duty because our clients need to be informed about what and how the services are being provided. It's very, very important to cover HIPAA. It's actually legally required to tell them about HIPAA and privacy practices. They have to sign the forms at essentially any agency I think that you work at. There should never be any surprises is really kind of the a good rule of thumb with duty to inform. And so I think I just kind of covered this stuff on this slide. This does kind of transition into letting the clients know about your role as a mandated reporter, that if their life is at risk, that you will take action to protect it, even if it means violating confidentiality. So that is a very important piece to let your clients know, and part of that is for the sake of maintaining the relationship. If you have never told them that you have to violate confidentiality in that situation, you still can. It will just do damage to, often do damage to the client-provider relationship. even informing them that you have to do it and then having to break it can impact the provider client relationship. But again, that's the fun part of being a mandated reporter. This part I mentioned already, talking about giving your credentials, your specialties. So they have an idea of what you're able to provide, and then they can self-determine if they want to go with you for your service. Duty to report is also referred to as mandated reporting. So we, in the helping professions, so that includes social work, have a legal obligation to, I like how they phrase this in the first bullet, certain outrages against humanity. That sounds very dramatic, but when you're thinking about safety in a matter of life and death, it is pretty accurate. So we have an obligation to report if we suspect there's criminal behavior that includes child abuse, child neglect, molestation, incest, exploitations of persons who are elderly, physically or mentally challenged, or the developmentally disabled. And so all those vulnerable populations, we have a legal obligation to protect, and that often requires us to report to the authorities, CPS, APS, suspected outrages against humanity. Now, duty to warn and protect. This may be less familiar to everyone. We talked often about mandated reporting, but this one doesn't always get brought up in the everyday conversation. But social workers have some responsibility to warn potential victims if our client indicates that they are going to harm them. So this is kind of that same human rights perspective, although it's not protecting our client, which usually we see as, well, in some ways it might be protecting them. We often see that we have to report in order to protect the life of our client, but duty to warn is when we report in order to protect the life of somebody that our client is threatening to harm. So often the one that we think of most is if a client threatens to do physical harm or intent to harm or intent to kill or murder somebody. That typically is the one that we think of first. Now, there's a little slight nuance, and I think I covered this in a different slide, that with the duty to report, so mandated reporting, we can report suspicions even if we don't have evidence necessarily to back it up. If somebody has shared with us but we haven't interviewed the perpetrator ourselves or have super organized and factual information, we still have to report suspicions. With duty to warn and protect, there's a little bit more encouragement to make sure that the accusations that we're reporting are actually valid. If you think about someone blowing off steam in a therapy session saying, oh my gosh, I could just murder my mom or something, you use your clinical assessment skills to be like, okay, is this a serious threat? Is it not? Again, consulting supervision, going back to the Barsky's model, so you're not making those decisions alone, but you do kind of have to flesh out a little bit. And often, sometimes there will be false positives. You might report something that actually didn't have any teeth to it, but the benefit to public safety is often more important. So the big case that kind of prompted duty to warn laws to be implemented in states, and not all states actually have a duty to warn, but Michigan does, is the Tarasoff case, where at the University of California there was a student, Tatiana Tarasoff, who entered into a very casual, they call it they kissed a lot, so they kind of just made out with this other student who developed a romantic fascination with her. And she didn't really want anything more than the casual interactions that they had. And this just really set off this individual. And so he was seeing the school psychiatrist at the time, and he had disclosed to the psychiatrist that he had intent to harm and potentially murder Tatiana. Now, the psychiatrist was faced with the dilemma if he should report or not. He ended up reporting it to the campus authorities. The campus police arrested him, interviewed him, released him, and he ended up going on to murder Tatiana. And so this case has prompted the importance of duty to warn, specifically around that. I talked about this slide earlier. So yeah, those are the areas of duty. The warn and protect can also fall under some other umbrellas, but primarily